Live, okay. Good morning. It's February 1st. This is Senate Judiciary. We are starting off with SS 163, which is essentially going to serve as a vehicle, or we'll just call it a vehicle for regarding what the Judiciary branch is requesting in terms of resources. So, and of course, it's subject to change, and that's pretty much it. So I'll pass it to you, Eric.
Yes, thank you. Thank you, Senator Hashim, and good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to do a walkthrough of S-163, which is an act relating to establishing two superior judge positions. As Senator Hashim was noting, the bill does exactly that. The title reflects what goes on in the bill substantively, which is establishing these two new superior judgeships. It's based on, the language is based on actually language that passed in the budget last year. Act 78, the big bill, also had language that established several positions in the judiciary, some judicial assistants, a superior judge, and a law clerk. So this language is virtually verbatim to the language that passed. So to be consistent with what's been done previously, when new positions in the judiciary are established, including judgeships. So the one last year created one judgeship, this creates two. Otherwise, though, quite the same. So you see when you look at the language, subsection A on page 1 establishes the two new exempt positions, two full-time superior judges. So that's the enabling language that actually creates the positions. Then in subsection B, you'll see that there's some specifics about these positions. These are to make sure that the processes and the appointments are consistent with the Vermont Constitution and with the Vermont statutory scheme for the appointment of new judges. And those specifically, RUC subdivision number 1 points out that it's for a 6-year term, and that's in statute as well as in the Constitution. So the Constitution provides for 6-year terms for judgeships, so this making clear that the term of the judge position that's being established here is consistent with that constitutional provision, which is a 6-year term. Secondly, you'll see that the term commences, that's line 15, page 1, on April 1st, 2024. That also is in statute, so judicial, the judge positions, judgeships, start on April 1st of every year. That's when the 6-year term commences. So this is making clear that this is in alignment with what's in Vermont statute and the constitutional provision regarding the 6-year length of the term. Subdivision 2 also is making clear that the judicial positions created are going to be subject to the judicial retention process, just like any other judgeship is. So as everybody in this committee is very familiar with, that committee in fact is having its first meeting with the judges tonight. But that process of judges declaring whether they want to be retained after their initial term, and the judicial retention committee that is a joint committee of the legislature that oversees that process and then recommends a vote to the General Assembly. This is just making clear that these new judge positions are also going to be subject to that judicial retention process. Lastly is the amount of the appropriation, which you see is over on page 2. These are for 2 positions. Also, I know that you're going to hear testimony from Scott from the Joint Fiscal Office on this, so I don't have any specifics on the numbers other than I base those on what working with JFO to come up with, and you're going to have to align those eventually with what's in the big bill as well to make sure the numbers are consistent. And that's about it, really. Pretty straightforward, and happy to answer any questions. So.
Thank you.
These are permanent positions, not temporary, just to get through the backlog.
Yes, exactly.
Thank you.
Yeah, sure thing.
Next up, we have Scott.
Good morning.
Morning.
For the record, Scott Moore, Joint Fiscal Office. Looking at this bill, the language looks at creating 2 new judge positions. For fiscal impact, those judge positions, we would advise would also need a judicial assistant. So although you see in the fiscal note that I have in front of you, the bill doesn't appropriate those two positions, but that would be an additional cost. So you can see here, the language of the bill has $539,246 for the two superior judges. There'd be additional costs of $169,418 for those judicial assistants.
418, sorry.
418, yes, sir. And here's a copy if you'd like.
Oh, thank you.
So the one note I would mention when it comes to reconciling with the governor's book, the governor's book recommendations do have a slightly different cost. It's $12 cheaper than it's on here. So very immaterial. At the same time, I wanted to point it out that for the judges, there would only be $539,234. So $12 cheaper.
Thank you.
I'm not terribly, because $12 seems somewhat de minimis, but I am curious as to where that discrepancy arises from. Is it different math, different pay rate? What?
I'm not 100%
Okay.
sure. Trying to track down, narrow it. You know, I'm guessing it's just some rounding and
Okay.
on this number does include salary and benefits. And when we look at some of the different benefits and salaries, you know, 33.4 becomes 35, stuff like that. So we might have some of those things. So that's my best guess in terms of narrowing down exactly where that $12 came from.
Okay. Again, $12 does seem somewhat de minimis.
Yeah.
Thank you.
I
I think we should have them in our folder.
Oh, we do? I'm sorry.
I didn't.
It's attached underneath the bill.
It's right in front of you.
Ah, yes.
Okay.
There it is.
Oh, no, please. I
Thank
made
you.
extras just in case.
Thanks. And next up, we have Judge Zone.
Is it okay if Terry and I go at the same time?
Absolutely.
For the record, Tom Zone, Chief Superior Judge.
Terry Person, State Court Administrator.
So the request for two Superior Court judges is one that we think is, we generally don't talk about policy. We stay out of that. But this is a policy I actually will say we like. We support this. It's something that is important. At this time, the plan would be that one of the judge positions, just to back up, when we get a new judge, that is not a judge who is going into a specific slot. What happens is during each year, during the spring, the judges are given assignments for the following fall. And so we have a rotation schedule with judicial assignments. And we assign to different positions that are established. There would be, for instance, you have a judge who's in the criminal division in Barry, in Washington County, a judge in family, and a judge in civil. And so each year we switch judges and we move whether it's courts or counties. The plan for these positions, one would be to establish a rotation slot with a new judge position that would be a northern float. This is anticipated that they would be working in the Chittenden County area. That would be in the criminal division where we currently have backlogs, as well as working in the civil division. They would also possibly be available to help out in Addison County or Franklin and kind of areas around there. But that's the idea, is to have that float to be able to help address backlog and ongoing case issues. The second slot position would be a statewide treatment court judge. We currently have judges who leave their normal dockets to do treatment courts for one day every 2 weeks. And having one judge in the 5 courts would enable that judge to be able to travel around, have consistency and subject matter expertise in those courts, to serve as a resource for other counties which may be considering treatment courts, and also to fill in other dockets when available. And we actually had a meeting this week with the National Center for State Courts, 2 individuals from there who, when we were talking about this, the individuals we spoke with actually thought that was a pretty good idea too, to be able to do that type of position, to have one judge do that. And again, it wouldn't mean that one of these 2 judges who is appointed under the bill is the treatment court judge. They won't be. It will be someone who is an existing judge who I would assign, and put them into that slot for next fall.
Can you speak a little bit to the importance of a specialized treatment court judge and why that you feel like that is important to have one person doing those specific types of cases?
Any judge who's doing the treatment courts right now receives training beyond that the other judges receive. And so having that specialization, having that specialized training is necessary to understand strategies and the way that we're dealing with the disorders that are in the treatment courts. So having someone with a high level of skill is important. Having someone who is focused on that as their only docket doesn't have them being taken away by potentially, okay, this emergency just came in my normal docket. I don't have to go do arraignments today. I don't have to go and do a motion for bail review. In other words, it lets them have as their primary focus the ability to address the treatment courts, and we can then focus additional training and resources to assist them in doing that. So it really lets them have that expertise for that docket in a way that it benefits not only their dockets, but actually benefits the other judges, because if we send a judge away to training, he or she can come back and help train other judges in our state with what they've learned. And so having one judge with that focus, we think would benefit us in that regard.
Thank you.
So if I'm recalling correctly, we had a joint hearing a few weeks back with the House Judiciary Committee, and if I recall correctly, you had mentioned that at the current rate, we'll get out of our backlog in 20 to 30 years. Was that?
That's a number, I think Mr. Valerio has used that.
Oh, that was,
Those numbers, long numbers like that.
okay, that was, all right, sorry. With the two added positions, I mean, how substantial of an impact do you feel that will have on reducing the backlog? Will it increase the rate?
I can't give you specific numbers and say it's going to go down by X, Y, or Z. I can tell you that we do believe it would have a substantial impact, knowing the gaps we have for coverages, knowing that the areas that we can add to. Case in point is with the 5 new judges who were appointed, the ones who the committee confirmed last week, we actually have them, if you will, deployed. They're in the courts. We are adding days in the dockets. We are adding jury trial days. We are adding hearings. It is actually right now going to start showing results. If we can expand on those types of results in other areas, it's going to bring down the backlog numbers. This, of course, depends on what's coming in. If we have a number of legislative enactments that say, well, this case now, it takes priority, or that case takes priority, you have to get this in within this much time. Those are factors that we can't control. But for the areas that we can control, for scheduling and bringing cases in, getting 2 more judges, it will have an appreciable and, we believe, noticeable impact on the backlog.
Thank you. And just one more question for both of you, but given budget constraints that we have, I'm curious about cost-benefit analysis. And I know you might not have numbers right in front of you right now, but could you speak generally about just the cost versus the benefit of having these 2 new judge positions and the impact it will have on the cost of having cases linger for years longer than they should be?
Well, Senator, one thing I was going to mention when you asked about impact on the backlog, the most direct impact would be realized by those 5 judges now who leave their regular dockets for 1 full day every 2 weeks to attend to the treatment court dockets. This would enable them to not leave their regular dockets and instead have that additional full day every 2 weeks to attend to the cases in their docket. So that, to me, is where you're going to have the most direct impact. Would have been 5 days otherwise, if you will, not scheduling hearings or processing the hundreds of cases that are normally processed in 1 day. So I just wanted to mention that as kind of where you are going to see the most direct impact.
Thank you.
And the other, you all, the legislature, were so grateful for having approved the Southern Float last session, and that already has enabled all kinds of scheduling to enable that float judge in the South to be able to move cases much more quickly. Judge Zoning, who does all the assignments, can speak to the exact specific, scheduling changes that have been made. But already, I'm gonna say dozens of cases have been moved as a result every time that, that special scheduling can take place, so.
Case in point, there were cases I understood that were scheduled into, this is several weeks ago, there were changes of plea scheduled in Rutland that were out into March because we didn't have the judicial resources. My understanding is, since we now have the other two judges who have started there with the float, those matters have now been advanced, and if they haven't already been scheduled for this week or next week, that they are coming in a month or so earlier. We are speeding things up. You ask about basically the cost-benefit analysis financially. As of this morning, I believe there are 400 individuals who are pretrial detainees. If we are able to have additional judicial resources, those numbers should come down because we're addressing the cases at a faster level. And that's a cost.
And so if those numbers are going down, the general cost is less.
If we have if we are handling the cases for the pretrial detainees, there should be less people in jail because they're no longer going to be pretrial detainees. The cases will be disposed, and however it works out for a resolution, they'll be in that status.
Thank you.
As a quick follow-up to Senator Hashim's question, is the the cost of detaining a pretrial detainee the only sort of cost of the backlog? I imagine that there are other places where that is actually costing us money. And maybe it's hard to.
It's hard to quantify sometimes when you look at the victims who are waiting for their case to be heard, the defendants, the cost of them with uncertainty in their lives. And so those are the intangible costs and the public interest in moving the cases ahead. There's also, we believe, when you reduce the number of cases, when you start addressing that backlog, and we start shortening that time between the charges coming in and disposition, that's going to ideally result in benefits to the public. Because what are we hearing about in the legislature and in the meetings that we have in the communities? We're hearing that there's people who are continuing allegedly to violate the law while on conditions, who are continuing to victimize. So the shorter period of time till we can get to resolution on cases minimizes people being on pretrial supervision. And if they're going to have a consequence, that consequence is one that could have supervision, thereby providing them the needed correctional treatment as well as providing public safety. So those are costs that we can't say, oh, we're going to save X amount, but we do know that if we have individuals who are no longer engaging in crimes, that's going to be a benefit that's going to financially for segments of our society and the courts.
Thank you.
So just to condense what you're saying, as I'm understanding it, addressing the backlog at a faster rate will help improve public safety. Is that correct?
I believe so, because one of the concerns that's addressed is our individuals who may be found guilty being supervised properly, receiving correctional treatment. And if you have someone who needs treatment, who needs rehabilitative programming, and it's 2 years or 3 years and they're not getting it, I would think that that's not good. We need to shorten that time to let people get the treatment and programming earlier on in the system so that they can benefit themselves and thereby reduce any recidivism.
Thank you.
I got a few questions. So Judge Zoney, how many positions do you presently have judgeships? Including, that's including your vacancies, correct?
That's correct.
So
right now we have one vacancy, so we have 37 positions, 36 are appointed.
Okay, so you're looking at 39. And so we just got this thrown at me. I wasn't aware of this judicial system. So what are the costs you anticipate, or hidden costs that we're not aware of with these positions?
Well, I guess Scott had inquired or asked.
He's gone.
Okay. And he'd asked for the cost of the judge and whether it included benefits or not. And Greg Mosley, who's our Chief of Finance and Administration, said in response, well, typically a judicial assistant is associated with a judge. So that's where that came from. And I apologize because it's not something that we had discussed before and we would have otherwise indicated. But that's where that came about. And when he asked, are the benefits included in the judge position, he was responding to that question and then said, and they're also included in judicial assistant positions. I think Senator Sears, as someone had asked, what was the fiscal year 25 request in total? So we had provided the judicial assistant figures in conjunction with that, and, so the bill says 2 judges. I mean, is staff support for every judge, but it wasn't an analysis that we had done, or we weren't suggesting that you modify the bill to add to additional judicial assistance. That's where the kind of reference came from. But there are costs associated with the judicial assistant.
And in Vermont, when you have a new judge, we don't get assigned a judicial assistant. Some states have that. When you are a judge, you get your own secretary or administrative assistant. We don't have that. So even if there was no judicial assistance in this bill and we got to judges, we still have the ability to have judges do the work. Now, do we need judicial assistance? Yes. We need a number of them, even if we got no new judges, we still need judicial assistance.
Okay, so having said that, so the 708, 664 includes everything? Benefits, salary?
Yes.
Okay. So, and I know this isn't part of the bill, but it does blend in with this bill. S17 provided that Judiciary come back with a summary of our courts and so on and so forth, and I read it. And it's a large request, I might add, between security and positions and whatever else. Would that change with the addition of 2 more positions in judicial assistants?
2 more judge positions? I don't believe that would change, because the S17 report recommendations are based on courthouses and security coverage for courthouses, irrespective of how many judges are in the courthouses. You're saying, I mean, it could potentially be, we would have the ability to have more hearings, but in all honesty, you can only have so many hearings depending on how many courtrooms you have in each courthouse. So I don't know that it would increase the security, the cost that was in S17. Is that your understanding?
That's my
Okay, so, and my last question, and thank you for your patience here, is I'm concerned about the trickle-down effect. Okay, and I see we have a couple of gentlemen here that will respond to that. But there's always, when you ask for something, for every action, there's a reaction, and so I'm concerned about additional costs that we're not aware of here. So, I support, we're in a dilemma. We're clearly in. We need to do something. I'm sick of people bringing up the pandemic, the COVID, or whatever else that's behind us now. We need to get through this. And if this is a way of looking at it, I can't say yes or no at this particular point. I'm concerned about the overall effect as to what's going to have on this. I had one other question, and it just escaped my mind here, but it had to do with Judge Zoney and Terry here. So if it comes back to me before we leave,
Let us know.
I will certainly ask that question.
In the meantime, I think Senator Bohosky has a question.
I did. So, it's been a long time since I've found myself hanging out at the courthouse or in a courtroom. So this sort of day-to-day happenings, I don't know exactly what they look like, but so thinking about just any workplace, if you don't have the support staff that you need, arguably it probably hampers the efficiency and ability to do the work. If you were to not get the assistance, that's not the word that you used. Yes, it was judicial assistance. Okay. How do you envision that would impact the efficiency and ability to do the work and work on clearing that backlog?
Well, it would impact, as Judge Zoney said, a judge doesn't have kind of a dedicated judicial assistant doing his or her work. So it's not kind of like that direct of an impact, but spread out across the entire system. We would say we're under-resourced, and as a result, not as many matters get processed as should get processed on a day-to-day basis. And that does contribute to the backlog, because then you have those cases that aren't processed, that are sitting there longer and adding to the numbers that are in the queue. But we've been under-resourced in the courts for years. And it's always, I just speak from the 9 years that I worked in the trenches, if you will, and it was constantly triage and constantly trying to keep your head above water, knowing that you didn't have as many people doing the work that there should be.
It just came back to me. And I think I had asked this question when we had our joint meeting over there. So now when we're looking at 2 new positions, so on and so forth, do you anticipate this just being status quo, business as usual? Are you looking at adding hours on? I refer to like night court or Saturdays or something along those lines there, because at the present rate you're going and listening to other witnesses, it take 20 years, we're at 108% that we caught up on the backlog. It take another 20 years at that pace, we should be at 160% as far as taking care of the backlog. So is this still going to be, I mean, you can put, you know, as many worms as you want on a hook, but they're going to catch one fish here, okay? So we're going to add more positions. We got the same amount of courts, same amount of courtrooms available. How do we anticipate taking care of our backlog if in fact something doesn't change in this mix?
We don't have the same amount of courtrooms available. In other words, by getting more judges, we do have available courtroom space. So we can run extra courtrooms. We can bring in more cases. There is that line in some counties that you maximize. If you have 2 courtrooms, you can't run 3. So in some counties, we will be firing on all cylinders, if you will, to do that, where we haven't been. And so we've been doing that in Rutland. Right now, in the Rutland Criminal and Family Court in the McCaffrey building, there are 5 courtrooms. And previously we had 1 judge in criminal, 1 judge in family, and then we have the magistrate coming in several days a week. Now we have criminal, family, magistrate, and float. So you can have days where previously there's 2 courtrooms going, where we're now operating on 3 courtrooms or 4 courtrooms in one day. So it's not business as usual. It's employing processes and strategies to deal with the backlog. Another strategy that we're going to be doing is when we have additional judge resources, we schedule additional jury draws. Instead of always focusing on the criminal docket in the criminal building, where you have, let's say, a retail theft that's competing with a sex assault case to be tried, we are going to be trying to implement separate jury draws and using some of our other courthouses with the judges there to try to address other types of cases in those courts where we might not need to have custodial individuals in custody. And so we're implementing strategies that are going to maximize whatever we have.
I think the treatment court dedicated judge position kind of shows, you can look at it most clearly, because you have right now, again, pulling those 5 judges from their regular dockets on the treatment court day. That's typically in a separate courtroom. So right now, with the treatment court dedicated judge, they are handling those cases in that courtroom. In the meantime, the other 5 judges are handling their regular dockets in another courtroom. So you're getting that much extra judge time, that many more cases processed, if that's helpful.
And Rutland is a great example of that, because Judge Valenti was in the family division. So one day every 2 weeks, there was no family court on Tuesdays. He was doing the treatment court. Now, 5 days of family court. We're having family court every Tuesday when he's in treatment court, because we now have him as a float to be able to do that. And if we then had a single dedicated treatment court judge, and we would then, Judge Valenti would be doing something else, perhaps in one of the other counties where he's floating to, or in Rutland. So it really presents an opportunity for bringing in more cases and having it as a float. We can strategically place that judge. It's not when you start, you're always going to be going here. Here's the plan, but we know the goal. And sometimes you have to change the plan to get to the goal, and we would respond accordingly.
And similarly for the vote position, and this is most apparent in those single jurisdiction courthouses, the smaller counties where you have 1 judge that's covering criminal, family, and civil. So if they can only do one courtroom each day. So if you have a float position that come in and can take that case that they've been waiting to hear, but they didn't have the judge time available, they can hear it in one of the other courtrooms in that courthouse. We're trying to be very intentional with the requests. We're not just saying, oh, give us more judges. We're saying, where can we use them? Where are they most needed? And where would be the strategy to have optimum benefits from that additional position? So that's our attempt anyway.
Yeah.
Thank you.
I certainly appreciate Senator Norris's focus on the physical resources available. Not every case is resolved through the utilization of a courtroom at all, is it? Are there cases that...
That's a very good point. And in all honesty, just having the ability to have a judge to cover a case so that a jury draw or a jury trial can be scheduled, many times they settle. But it's only when you've got that date looming and that opportunity, and John and attorneys Valerio and Campbell can speak to this especially, that's when the cases move. And that's why they didn't move during the pandemic years when we had all those trial dates halted.
Do you, and maybe you don't know this off the top of your head, have a sense of what percentage of cases actually have to go to a courtroom versus the cases that end up?
Yeah,
Well, in 2023, 99.58% were resolved by dismissal or plea agreement.
All right.
In 2022, I believe it was 99.66, within a tenth or two.
So very few are actually traveling to meeting excessive, or a lot of courtroom research. Yeah. Thank you.
Yeah, your question might be too, what percentage only settle when you get to the jury trial date? And that would be interesting to look at, but I think it's a lot. I mean, you might have 30 cases scheduled for jury draw and 24 of them settle. I mean, you all would have better statistics.
Statistically, across the country, the most effective tool for having cases come to a resolution is the firm scheduling of a jury date and having that right up against the case.
I also just want to confirm, is your current official request for 2 judges and 2 assistants?
Well, and again, we apologize for not having this kind of coming out of the blue. It was from an email that came this morning before Scott came to testify. So, I mean, we are grateful for the judges, and I guess if 2 judicial assistants can be added to it, that will then reduce what we're asking in our regular budget requests, certainly. But as I said, we're desperate for judicial assistants as well. It's the judge position that is the single most, in my mind, effective factor for moving cases out.
Okay, thank you.
Just got one quick follow-up. In reference to judicial assistants or additional court staff, are there enough applications for those positions right now? Are we fully staffed in that area? Or even if we say, okay, we're going to add 2 positions, if we don't have the applications or you're already sure not the courtrooms, what's the status of that?
You know, it's interesting. We've been actually very lucky in terms of having applicants for the positions that we have vacancies kind of on an ongoing basis. There's 300 or so, you know, around the state, and somebody is always kind of leaving or coming. But I'm going to say in the last couple of months, we have had fewer applicants than before, so it might be cyclical. But we really, for a stretch, had very good luck with applicants, and we've done more outreach, kind of more proactive recruiting for applicants going to schools instead of just posting something and hoping that people apply. We're going to community colleges, going to schools, trying to encourage job fairs, things like that. Because there's a great interest, especially among the young, to do a job where it's public service, where you're helping your community, you're doing something very meaningful, you're preserving the rule of law, you're helping to an aspect of society that has an impact on your community. So we've had very good luck with younger people being very drawn to that type of a job that has meaning. So, but in all honesty, in the last month or 2, we've noticed that there were fewer people applying. We would just, you know, continue our efforts to make sure that we are fully staffed. But we had good luck up until the last couple of months with many applicants and having good applicants among the pool.
Thank you.
Great. Well, if there's no other questions, thank you for your testimony. And next up, we have John Campbell.
Whoa, yeah. Hey, Jesus. There's little guys here.
John Campbell, Executive Director, State's Attorneys and Sheriffs.
Thank you.
I'm here. First of all, I agree with 99.9% of what John Zoning said. And, you know, here's the situation. I'll be very candid. Is this problem did not start overnight, and it didn't start with just COVID. The fact of the backlog and whatever. Unfortunately, Vermont has an infrastructure of the courthouses that is older. There's a few modern ones. The state's attorneys, the defender generals, the court staff, they were basically, the legislature they did not see that as a priority in past years to increase it, because I don't think anyone really envisioned the the state of where we're at right now with, let's just say with the criminal, I'm not gonna touch the civil aspect, but in the criminal area. And, so I think we're looking at it, to me, I see this as, basically putting your finger in a dike of like an 18-inch pipe coming out with, with water spraying out. I mean, this is gonna help a bit, I believe that to be true, as long as you're trickle down, what you mentioned, the fact that when we get more judges, we're already down people, Matt's down people. You need to do the whole system. If we do it just piecemeal, it's not gonna be as effective as to do the job I think that you all would like to see done. Just for instance, and I think you probably already heard these statistics, but let's say, I'm gonna go down like just 5 counties. Moyle County, the average caseload is 573 cases with 3 murder cases pending. Windham County, 476 cases per attorney with 6 pending murder cases. Franklin County, 450 with 4 pending murder cases. Rutland's got 5 pending murder cases with 424. And this goes on and on. Here's another one. Bennington County's got 16 pending murder cases. Now, I'm sorry, if you've lived in Vermont long enough, you didn't see these numbers before.
Mm-hmm.
You didn't, find that there's all these types of cases. So, we got to do something. If we don't do anything, this is just going to be a continuing problem. It's going to continue to roll around. And we do a piecemeal. It's doing a disservice in my mind to everyone involved. I mean, I received an email from one of the SAs yesterday telling me that her staff is dying. They're just so overwhelmed, and it's going to be hard. People want to quit because of the fact of all of the pressure of the work. People don't have time to deal with cases individually, which I think is one of the biggest problems, because when you have some time and you can actually work with defendants and try to come up and craft solutions that are not that would help to have them decide to change lifestyles or whatever, instead of just saying, okay, here it is, you got a fine, or you're going to do not work for anymore, we know that, but or incarceration. So it doesn't give you those times to really work with the people that are coming into the system. Whenever, again, I think it's definitely, I would definitely support the addition of the judges. I think 2 is too little. But you also have to, I think, take into consideration, the rest of the system, because, you push it in one place, it's going to come out 2 other places. So if you don't have the state's attorneys able to and the defense attorneys able to do these things, you're never going to get to those points where you're going to get to the resolution. And if I can hit that point, the point of the resolution, I don't disagree with the 99% settling. But those usually come at the very end. They don't happen right away. The defense, especially now, I think defendants have more of a, they realize that cases are not going to be tried or not going to be resolved. So therefore they're saying, well, I can put this off for a while, and why not do that? I don't think they're not rushing to get a resolution. And I understand that. And if I was a defense attorney, I'd probably be, taking the same tack, saying, well, you know what? You're not going to see this case, this retail theft case, not going to go to trial. Sure, not going to go to trial for at least 2 years, 3 years, if that. And then where is everybody during that time? You lose witnesses, whatever. So there's not an impetus to resolve it, except for when it comes to those times when, okay, you got a date certain, you're going to trial. And that's when you see the resolutions. So.
Thank you for testifying. I agree with you that, things shouldn't be done piecemeal. There's a lot of different moving parts. So will you also be making a request for the state's attorneys and sheriffs?
We did ours in the budget. And actually, this is the first, it's usually obviously done in a budget, but I think this is good because it presses the issue. We are, in order for us to try to get down to an average of just 250 cases per state's attorney or DSA, it would take 10 to 14 deputy state's attorneys. And that's not even mentioned the chances of us getting 14 positions, I think, are probably pretty slim. But any workload over that, I think, is outrageous. And if it was you know, if we had malpractice against, state's attorneys or prosecutors, anybody handling those, 300, 400, 500 cases, you're basically bordering on them committing malpractice. You just don't have the time to devote to, properly. So I think that, we owe it to, not just because I'm the executive director, but I mean, I see these people. These people, they're like, just burned out.
Thank you. And my next question, regarding the backlog in general, same question I asked earlier in public safety. Do you have any thoughts on whether addressing the backlog more quickly with these additional judge positions will have any impact on public safety?
Yeah, I do. I think the one key is that the fact that the people who have found themselves in the system are out there. And while they're out there, I think evidence will show that many of them are repeat offenders, that they're committing other crimes while they're out. So this quicker we can get some resolution and get to them to either some of the folks who have drug issues, get them into rehab, get people with mental health issues, have them get involved in some type of mental health treatment. The faster we do that, I think it would save the general, the public, incalculable dollars.
Thank you. Senator Bowles.
Thank you. So you say that many of the people who have been charged and are out in the community are committing more crimes. Do you have statistics on how many?
I can show you that I think we have stats on, which I think you've been given. But repeat.
I think we got that in our joint.
I'm wondering what percentage, because I want to be careful, because I think sometimes when we use loose language like many, it can inflame a perception that everyone, and so I just want to be careful that we're actually talking about.
My better half complains about me doing that all the time, and I say, you always do that. So I've been taking that out of my, vernacular, but unfortunately, the Irish in me gets going. Let's see, there's, of the 21,000, this is of December 10th, of 21,000 pending criminal cases, 58.68 of all pending criminal cases were alleged repeat offenders. So 2 or more pending criminal dockets. There were 8 people with 25 or more dockets, representing 297 pending dockets. There were 689 people with 5 or more open dockets, representing 5,587 pending dockets. I would think, looking at these stats, I would say that we're seeing a lot of repeat offenders that are committing a good number of crimes. Well, obviously, almost 60%.
So dockets aren't the same as people. And I'm also confused. You said there's 689 people representing 576 dockets. How can there be more people than dockets?
I said 689 people have 5 or more open dockets. So your question to me, I thought was, are we seeing these repeat offenders and I think the answer is we are seeing a lot of people repeat these crimes. I would have to do the math quick here to see exactly how many people that have this, but I think we just see, what is this, 3,485 people that have, 12,000 dockets. So those are basically 12,000 cases against their charges. I guess it really comes down to how it's dockets, whether it's an actual individual charge or a combination of charges.
So my question really was, what percentage of people who are released pre-trial are then going on to commit more crimes? And and the data between dockets and people and how they're charged, it sounds like maybe that's a really tough number to get at.
I probably don't have to answer the exact question you're looking at. I think this is probably the closest data that you can find that would indicate people with repeat offenses.
Okay. Thanks.
Senator North.
Good morning. So you said that your 10 to 14 positions were in the budget, placed in the budget prior to. So was that in anticipation of this request for 2 more judicial positions? Or is that going to have an effect on that 10 to 14?
No. In fact, actually, the administration, we were given 5% increase, so we would probably lose people right now with that. So ours is, when we go before appropriations, we are going to be asking for that. in order to get the caseloads to a manageable, state. We didn't, I mean, I anticipated, of course, that the courts were gonna ask for additional judges, and I assume that Matt's gonna also ask for additional positions. Maybe not, I guess he'll tell you in a second, but, so those are the ones that we will be asking for that. Plus, you know, we get the victims advocates as well. We have victims advocates who have 700, 800 cases, themselves, that they're dealing with. So
John, this is in the budget, not the budget adjustment.
this, would be the budget. Now, somebody had mentioned that somebody talked about putting positions in the budget adjustment. We didn't ask for anything in budget adjustment, so they may have, but somebody said that they saw that they were going to add a position or two. I'd have to check up on that. Annie's the expert on that.
Yep.
So do you have like just a ballpark figure for the cost of one deputy state's attorney with benefits?
I can get that to you. I don't wanna guess. I can get it to you before the hearing's out.
Appreciate that.
I'll make a call.
Thank you.
Unless it's on here, but they just threw it in my hand, you know, it's running, as I was running out.
Annie.
Yeah. I will get that for you, because I don't see it on here. Within 15 minutes.
Thanks.
All right, thank you.
Thank you.
Next up is Mr. Valerio.
Good morning. Matt Valerio, Defender General. What would you have me say?
I'd like to hear your thoughts on whether or not supporting this request will have a positive impact or a negative impact on the judiciary and in the backlog.
Can't hurt. You know, it's like, honestly, I see it as kind of throwing a pebble in the ocean. I don't see it as something that's going to make a huge difference. It'll help. You know, you have to anticipate what each of these, as I hear them being planned, it's the first I've heard of how they would be used. The northern, or I don't know if it's a northern float or southern float, northern float, should help in moving cases through the system. I can see how the treatment court judge would free up other judges to, so they wouldn't have to leave their docket to do treatment court. Treatment court itself, while a good thing, represents a really minuscule portion of the total docket statewide. So in and of itself, it wouldn't really handle much of a caseload, but it would free up other judges to maintain and stay with theirs. You know, this I don't see it having a significant impact on Defender General resources, but let me reiterate that we, under the current situation, if we went forward, meaning the Defender General system, level serviced, okay? Exact same number of people, no more, no less. We're barely hanging on right now. The state's attorney, I understand that John just talked about a 5% increase. Ours was a 4% increase. A 4% increase with us would result in the reduction of 10 contracts. That's effectively 10 FTEs, or what we call LECs, lawyer equivalent caseload providers, which represents thousands of cases that would no longer have lawyers in the system, that would actually get dumped into a more expensive way of providing that service. And that is, you know, it's problematic to me whenever there is you know, some other partner in the justice system increases capacity when you are not equivalently dealt with. Going forward, if we had what we have right now, if those 10 effectively 10 lawyers, 10 full-time contractors. And I'm not talking about positions in staff offices. I'm talking about, I have more flexibility than the state's attorneys do to cover caseload. Because a lot of what happens in our system happens in the conflict side of the caseload, as opposed to the staff side of the caseload.
What is the conflict side of the case?
It's probably 40 to 45%.
No, I'm sorry, I'm not familiar with that term.
Well, if you have a case that comes in and there's 3 co-defendants involved in a drug conspiracy, the staff office will get 1 of the cases. The other 2 will have a conflict of interest with the staff office under the rules that govern attorneys' practice. And those other 2 cases will have to go to get their own lawyer, but on the conflict side. And so those are what we call conflict contractors.
Okay.
So it's called them assigned counsel contractors. And those are what is, that it's a big part of what the backlog is being handled by now is the conflict contractors. This is something I've talked about in other venues about this, where the way you analyze conflicts for attorneys, you analyze them as conflicts with current clients and conflicts that arise out of former clients. The analysis for current clients is, I would, for lack of a better term, call it more strict. So the bigger your current client caseload, the more current client conflicts you have. If your backlog is big, your conflicts are more. If your backlog is smaller, your analysis is probably going to look more at what former clients, like the cases are moving through the system, and the analysis is different. I can go into the details of that, but it's not necessarily worth it. The bottom line is the backlog impacts the conflict system substantially. This is where a lot of these cases are going. So these 10 caseload relief contracts effectively that I put in place are what is handling this overflow from the staff offices. Take away 10 of those, which is basically what would happen, and you got a problem. So we're, just to be level service, the DG's office is $2.2 million short based on governor's recommended budget. And that is literally changing no staffing, no new contractors, no new attorneys, no new nothing, just going forward with what we have in place right now. All right. So, I would like to say too, and I want to, the statistic about 99% cases don't go to trial, that's true. But there's a lot of stuff that happens before you get to 99%. There are motions to suppress, there's discovery litigation, there's the discovery that goes on. All of these things, if you do it right, leads you to the point where you're going to whittle it down so there's only 1% of cases that actually have to go to trial. But there's a lot of work that goes on. It's not just people sitting around waiting their turn until they really do have to go to trial and now they're going to settle. There's a lot that gets you to that point, and state's attorneys are doing that work. Public defenders are doing that work. So if you look at another statistic, which is how many cases resolve for what they are charged with, that number starts to drop to like 50%. So there's a lot going on between the 1% that go to trial and the 100% that get filed that get you to that point of only trying 1%. We couldn't really try a lot more than 1% without grinding the entire system to a total halt. There's good parts and bad parts about it, but people who think we should have more trials, I'm one who actually thinks in some cases we should have more trials, but I don't even know if we could do more trials. I don't think the system itself could do more than 1.5%, even if every case that was tried or should be tried was tried. So
those conflict contracts, are they more expensive than a staff attorney?
no, they're way cheaper.
Okay.
They're in the range of 40 to 45% cheaper than a staff attorney.
Thank you.
I just wanted to, this isn't so much a question, but just comment on your testimony. So we had Jay Johnson in from the administration at the beginning of the session, talking, you know, I think it's fair to say tough on crime, new penalties, you know, different paths that would lead more people to be incarcerated. And I asked her straight up, in the governor's budget, can we expect that he will account for the additional numbers of cases to be tried and prisoners to be incarcerated in the budget? And she pretty much refused to give an answer at that point. Your testimony, I think, highlights that gap, that what he's put forward would cut your staff by 10 of these contract positions and would lead to...
Yeah, that doesn't count the, there's about, of the 10, you're talking about 1.5 million that is involved with the actual contracts themselves. And then there are what we call other personal services, which is like investigative work, evaluations, things like that. And then like the other support side of that, which is about another 500,000, which goes along with the,
Yeah.
it brings us to the between 2 and 2.2 million.
Right, and I just, you know, it's endemic, I think, in the governor's budget. It's not just this area. There are a lot of areas where he's talking a game in this way and yet not funding, and in effect making the situation worse, not just leaving the status quo. And that leaves us in the situation. I've seen this play out many times. The governor's recommend is way too low. The House recommend is low. And then Senator Sears sits down with you and the state's attorneys and the judges and tries to bring things up to a level where we can credibly say we're going to reduce the backlog, even if it's a small reduction. And I see that playing out in this moment as well.
Yeah.
As you say, the two judges might be a pebble, but unless we have an equivalent pebble for the state's attorneys in your office,
or at least don't go backwards.
right?
You know what I mean? That's what I'm saying. And I, you know, this is my 25th budget I'm working on. I see, I'm not naive about how this all works out. And, you know, everybody's got their constituencies that they need to answer to. State's attorneys are elected, governor's elected, you guys are all elected. And, you know, you've got people complaining about, you know, retail theft and other types of things, and you can't just ignore them. So, but, you know, it needs to be vetted, and then you got to make a decision cost benefit wise about what we're going to do. You know, from my perspective, what I've always said is I really don't care what the state's attorneys get or what the court gets or what you do with some of the criminal law, as long as we have the resources to address it.
And that's the key. So, and I'll just get off my soapbox in a second, but the governor used this phrase several times in his speech: let's not fund problems, let's fix them. And that sounds great, but it's hard to, you know, even if you think of your own home, if you have a problem, it's probably going to take funding to fix it. But when he didn't want to spend money, he used that phrase, and this is a key area where we're not going to fix the problem without paying for the fix. These are, you know, people that we absolutely have to run the system. So
we also, you know, I know that Senator, you talked about, you know, we're past COVID, and we should be thinking, you know, don't keep bringing up COVID, because that COVID is well, there's sort of COVID around, but it's not like it was for sure. But during COVID, we went into a little bit of a state of sort of suspended animation there. And it's kind of like when you do have deferred maintenance that you do on your house, when for whatever reason, like you're out of work or you can't pay for it. Now, 5 years later, you get back to it, and, you know, now we've got to deal with whatever the issue is. It's not just the fact that now you've got the money back to deal with it. What you find is 5 years later, what you're trying to deal with costs about 25% more than it did before you know, 5 years ago. And that's kind of the position that we are in now, because that deferred maintenance, that fact that we were not moving cases for a period of time, and the people who we deal with every single day, like mental health evaluators, doctors, investigators, and all of that, have jacked their prices by 25 to 50% what we didn't need to ask for during that period of time and legitimately didn't spend money on because nothing was happening. Now that we have to deal with it, it's costing us a lot more than it did in 2018, 2019 before COVID hit. So, you know, that's the reality of it. So one of the things I talked about, I'll give you an example. We get this thing that says, you know, build your budget to 3%, which is fine. You know, we do something, we show we'll have to cut all this stuff. We get a budget of 4% increase. In the meantime, our lease up in Burlington for the Chittenden office has come up for renewal. And the buildings and general services who we deal with, and I deal a lot with these things. This is what I do when you guys aren't watching me. Is I deal with
We always wondered what.
leases and personnel and like all that kind of stuff. Well, BGS comes to me and says, landlord wants a 12% increase, and we're recommending that you take it. I'm like, you're recommending that I take a 12% increase? I said, do you guys go and talk to finance who are having us build a budget for a 3% increase, and you're recommending that we do a 12% increase? They're like, oh, we don't talk to them. I'm like, well, how am I going to do a budget to 3% and you're recommending a 12% increase in the lease, plus certain things, right? Heating costs, other types of things. They said, I don't know if that's what the market is, right? So I said, well, you go back to them and offer them 3%. And they came back and said 10%. And we recommend that you know, we're going through this thing. But even when government has control and leverage to do what it needs to do, this is not me negotiating with doctors or providers of mental health services or those kinds of things who are doing evaluations to support our casework. This is like rental space that government through BGS negotiates on our behalf. They're coming back with numbers that are realistic in the marketplace, that at some point this lease is going to get done, and it's going to get done at 8, 9, 10%, not 12%, but it's going to be 2-3 times what our budget proposal is going to be. So it's almost like there's a recognition somewhere along there that, well, we got to do this, and then, but on this side, there's other things going on. There's a carving of bargaining position. I get it all because I've seen it so many times, but that's the reality of what we deal with. So even though we kind of went into COVID suspended animation and we didn't have to deal with a bunch of expenses during that time frame, those have now come back now that we're fully open for business. And so I always say, first thing, it's almost like I'm a doctor, right? First thing is do no harm, right? So the first thing is, let us go forward with at least the service providers that we have. And if you do something else, account for it. So that's kind of where I'm at with this.
Senator Bohosky.
Yeah, thanks, Matt, for being here. What, sort of setting aside, you were told 3%, what do you actually need to provide?
2.2 million.
That's the number
That's
that
the
would allow you to stay level at where you are, or actually provide, because it sounds like there's more need, even at level service, there's more need than you're able to meet.
I think that if we were level serviced going forward, that the 2 judges wouldn't mean anything, particularly to our workload. And I don't think that, because you can only get so many cases through the funnel, you know what I mean? Even if you have 2 more judges, and even if you have, whatever, 10 more state's attorneys, you can only get a certain number of cases through the capacity that we have, even with all the judges being in place. And I think that, I think I could make it work if I had going forward. You know, the thing I will tell you, the thing that will make the biggest problem for us is tinkering with low-end crimes.
Mm-hmm.
You know, I'll give you an example of this. I go back to the Dean administration. Criminalized furnishing and possession of malt beverage for minors. When that's a, I don't know if you know this, but kids under the age of 21 drink. And back then,
In many countries, they do it legally.
they were drinking, and it was criminalized. When I was first DG, 1 out of 5 males under the age of 25 were under the supervision of the Department of Corrections. And it primarily was the result of getting into the system by furnishing or possessing malt beverage, because they ended up on probation as, at the time, 16 and 17-year-olds were all getting charged as adults. That was the standard across the state. And they get into the system that way, and they stayed into that system well into their 30s. But, the number was shocking. 1 in 5 males under the age of 25. But it was the tinkering with the minor charge that did it. It wasn't, murders. It was volume. And that volume that comes into us is the thing that devastates us.
So just a follow-up. At the beginning, your testimony was that there are cases that should be tried that your office just can't try because you don't have the capacity.
I don't know if I said that. Under current, we're trying cases. There are cases I believe that should be tried, but it's not as a matter of capacity. There might be other things. I'm talking, you might be talking 0.5% compared to the 1% that we do try. But that's my evaluation of, there are cases that need to be tried because they come back to it. They come back later in other ways, post-conviction relief, challenging their pleas, wanting to withdraw pleas, change sentences after the fact, that kind of stuff. Those things shouldn't happen as much as they do if people were getting having trials and feeling like they had their day in court. But people are pushing resolutions that sometimes you shouldn't be pushing a resolution. Sometimes you should just be trying the case. But
okay, so I guess I'm sort of 2.2 million. It would be what you needed. I guess I'm asking you to sort of suspend, and what would the ideal number be so that you could really truly be trying every case that needs to be tried and offering legal services to anyone charged with a crime and not just people charged with serious crimes? And what would that be?
Well, I can give you gross numbers regarding that.
That's fine.
All right. So our budget right now is a little over 24 million. We represent a little over 85% of the people in criminal court. 10% don't get assigned to attorneys because they are not charged with a crime that would give them a fine of $1,000, probation, or jail. All right. About 5% of people are represented by private counsel, and that's fine. So if you added that 10% into our number, and we have a cost per case analysis that we do, and we have a payment per LEC analysis that we do, and they do tend to overlap a little bit. Some are a little higher than others. But just look at it in terms of 150,000 per lawyer equivalent caseload, and 10%. You're probably talking another $5 to $7 million.
In addition to the 2.2, or inclusive of that?
In addition,
Okay.
if you were going to represent everybody who walked in the door except for those people who want private counsel.
Great, thank you.
Senator Norris, last question.
All right.
By the way, I'm not asking for that.
I understand that, I know.
As
But,
ironic
I
as
was
this
just
may
doing
sound,
math. That's,
sitting in this room underneath the Golden Dome, we're going to try to keep politics out of this discussion, okay?
I don't believe you.
So, yeah, I know, right? So, in a perfect world, if you had your 2.2, Mr. Valerio, you were fully funded. Simple question, would the addition of 2 judges have any effect on your office?
Not much.
Okay. And secondly, you had mentioned a pebble in the ocean.
Yeah.
Okay, I mean, anything short of these hundreds, if not thousands of individuals within the state committing these alleged crimes, do you have any recommendations as to how we should address the backlog? Or
I've put out a few things that don't seem to be palatable. But I talk about the people who have been on misdemeanor conditions of release for now well over 2 years with pending cases and have not received any violations of conditions of release. I think it's appropriate for those cases to be dismissed. They've effectively been on probation, and what you want people to do is not commit more crimes. Though we could get rid of hundreds of cases in that way. I think that there are probably other cases that could result in deferred sentences, other types of incentives to get people out. So diversion and deferred sentences, those kinds of things. And there's going to be a core of cases, and this core of cases is building up that just need to be tried. And that number is bigger now than it was 5 years ago. So we should have no illusions that even dealing with all the minor cases, that these other ones are going to go away. Because there are some that have just been waiting because they have to wait, that do need to be tried. And I think that, with a combination of these things, we can get over like a 4%. I welcome, anytime I welcome John to.
Again, John Campbell, I don't disagree with Matt. Personally, I think that there probably are some of those that it would be trying to find them all, get those one, where it's shown that somebody has not gotten in trouble. But that's also adds to the fact that when you have so many cases, you don't have time to really go through and pick out and choose. I was just saying here to Terry and the judge was, what would be cool is if we had criminal mediation, which again, I'm not sure how the defense would do this, but have a day where, judges bring people in, let's sit in the same room, defendant, state, let's work this thing out. Start clearing through some of these smaller ones. So you have to go do that with the bigger ones, but some of the smaller pain type of cases and low level. I think being creative with something like that would help. I don't know. Again, it's asking.
In the old days, that used to be done. They used to call them chambers conferences, right? And nowadays, those are few and far between compared to when I was a younger lawyer.
Because judges really had the ability to sit there and push both sides and say, "State, you're being too harsh here. You're not. Just give them a better offer." Or
judges are reluctant, I understand, to do those things nowadays. That they're trained, frankly, to not do them as much as possible.
Thank you. Yeah, so we are about to go on a break. I do just want to distinguish that the question that we just heard was the impact on your office, although we did just hear about half an hour, 45 minutes ago about the pretty substantial positive impact it would have on the judiciary and the backlog as a whole. So just wanted to make sure that is clarified on the record. And so we'll be coming back at 10:30 for our next bill from Senator Bohosky. So thank you. Did you have?
I had a quick question for John, Terry, or maybe Matt. Do you need legislative change to allow judges to dismiss misdemeanors that have essentially served probation for the minimum sentence?
Theoretically, it could be done under Rule 48.
Yeah.
48B gives you the right to dismiss cases in the interest of justice, where the case is what is considered overall de minimis, and the interest of justice allow that to occur. There's some more nuance to my proposal that I've talked about for a bit regarding these things. One of the things I've talked about is we have people who pick up violation of conditions of release that aren't new crimes, and they don't involve a victim, so they have to do like curfew or would have something that it wouldn't otherwise be a new crime. I would think about those kinds of things being included. Some prosecutors are more aggressive in charging their violations of conditions of release than others, and so those numbers you can look around and see.
Yeah, and it all comes down to, again, it's like with the prosecutors. We do have different prosecutors, but that doesn't mean that necessarily that, they're all, Neanderthals and they want to put everybody in. It's just the fact that you got a lot of constituency. If you've got one person who's continually doing something, violation of condition, they're with the state attorneys or DSA, they're the ones who get, bitched at and saying, why are these people still out doing this? But what would be interesting if there was a way to, like, if we had somebody that could go to, let's say, through the dockets of our individual counties and say, pick out those real low cases and say to the DSA or, what about these? Can we bring these to this pilot or whatever you want to call it, to where we have the judges' chambers or, anyway, I felt.
Yeah, no, I'd love to talk a little bit more offline because it
Yeah.
seems like a really good way to just clear some of the stuff that's ultimately probably gonna get dismissed anyways.
When you saw up in Franklin County, one of the judges originally right after COVID went and took, what was it, 600 cases?
600, yeah, and that was a combination of, was it Jim Hughes up there and the public defenders
Getting together.
they got the group together, they went to the judge, it was almost effectively a joint motion, that just said, like, we gotta clear some of this stuff out.
Yeah.
Not everybody will do that, and that's, hey, like I said, they have their constituencies, they're gonna respond to the people who elect them, and, that, if all you think about is backlog, then I don't think that is all you should think about, but, you're gonna have different people handling it differently, so.
Thank you. So we'll